Call Sir William Sow.
Thank you, Mr. Speaker. The main purpose of the bill was to remove legislative barriers to the electronic monitoring of offenders released from a sentence of imprisonment of 2 years or less, offenders sentenced to intensive supervision, and this largely constitutes the offender participating in special programs and interventions for 6 months to 2 years. Intensive supervision is recognised as a community-based rehabilitation sentence, although I suspect many of us question whether that actually provides rehabilitation back into the community or whether people end up reoffending. It is given if the court deems that extra rehabilitation and reintegration assistance is needed in order to reduce the likelihood of reoffending, and consequently, according to the corrections, those who receive intensive supervision are generally offenders who are assessed as having a medium to high risk of reoffending, convicted of serious offences, or have complex, severe rehabilitative needs. And this would mean that the courts have the ability to impose electronic monitoring on such offenders. It does not mean that in all cases such conditions would be imposed. If it was chosen to enforce electronic monitoring on an individual, this would allow corrections to monitor compliance with offenders' whereabouts and restrictions in certain areas. The amendments also allow probation officers to impose reasonable administrative obligations on offenders in regards to their monitoring equipment. For instance, that the offender regularly charges the equipment or does not interfere with its monitoring capabilities. I note, sir, that in the Select Committee report and the amendments that they offered, they say that prisoners have for many years been temporarily released or granted escorted absences from prison for several recognised purposes such as funerals, medical treatment and work experience. And these amendments would clarify that such temporary release and removal situations may include a requirement that a prisoner submit to electronic monitoring for the duration of their temporary release or removal from prison. So in the Labour Party, we support the bill because we want to be able to give some confidence to the community in terms of providing safety, in terms of ensuring that those prisoners who are released back into society there's a tool that the Corrections Department can help monitor. And I've heard a couple of times now members of the government say that this keeps them away from the drivers of crime. In fact, Mr. Bakshi himself said earlier that the government was working really, really hard on the drivers of crime. And I'm not sure whether I agree with that, because when we look at the drivers of crime that have been recognised by the police over years of experience, they name families as one, and particularly where families are dysfunctional. They name youth as one, particularly where vulnerable youth and children are involved. They name road policing as another driver. They name alcohol, and they name organised crime and drugs. And when Mr. Bakshi said that the government, this was part of the government's efforts to tackle the drivers of crime, you almost get the feeling that somehow they believe their rhetoric that they're reducing crime and they're reducing the drivers of crime. And I'm not sure whether they can confidently say that, because when I look at the statistics that they released from the Corrections Department, where we have a total number of offenders released into Auckland region of about 12,000, and here's some numbers for the Parliament to entertain. In Auckland, the total number of offenders released as of 31st of July 2016, almost 3,000, 2,932. Offenders with violent offences, 491. Offenders with sexual offences, 46. In Waitemata, it's over 3,000, 3,129. Total number of offenders with violent offences, 497, and offenders with sexual offences in the Waitemata region is 45. And in Manukau, we have offenders with sexual offences, 80, offenders with violent offences, 1,080, and the total number of offenders released into Manukau is over 5,000. And this is one of the reasons, sir, why you'll hear people in Manukau banging on the drums and saying that South Auckland seems to be a dumping ground. And corrections seems to think that, well, this government seems to think that having the electronic monitoring is going to reduce crime. I don't believe that, sir. When they say that they are addressing the drivers of crime, I'm asking myself, what are they doing about poverty that families are facing? What are they doing about the growing numbers, the 300,000 children living in poverty? What are they doing about the growing homelessness of many families? Because under that heading of family, the police are saying that's a driver of crime. And I heard Mr. Bakshi and his colleagues say that they're addressing that, but they're not. Under the driver youth, we've now got more than 70,000 young people who are not yet in employment, education or training. I'm only addressing what that side has said, that they are doing something about the drivers of crime. And somehow electronic monitoring is going to reduce poverty, reduce homelessness, reduce the number of young people not yet in education, employment. You know, another driver is alcohol that they have said. But this is a government that refuses to be hard on the liquor industry and making it really, really difficult. So I want my colleague Louisa Wall made mention of people who have been released on extended supervision order. And we have a case in Mangere, but it's really a case out in South Auckland. It's a case that I believe touches many, many communities where a person who has rightfully served their time has been released into the community. But this person has been identified by the Ministry of Corrections as of high risk of reoffending. Now, the community were told that this person would be under 24/7 supervision, and I think he's also has electronic monitoring. But the reality, sir, is the difference between this person and every other offender that we've mentioned earlier is that the department recognises him as high risk of reoffending. In fact, they felt he was so serious that they applied for a public protection order so that he would be accommodated within the boundaries of a close accommodation next to a prison. But they failed to do that. And I keep asking myself, why is that? One of the drivers of crime, sir, is road policing, organised crime, and it involves the police. It involves the police. We are dependent on the police. And yet this government has underfunded police by 300 million. How can we then expect to solve crime, reduce the number of people who are reoffending, provide proper, sound, in-depth rehabilitative measures if we refuse to properly fund government departments? Yet that's what we pay our taxes for. And so I don't have any confidence, as others have raised, the fact that I hope that they don't think that this is going to be the answer to everything. And the answer to everything is not electronic monitoring. The answer to some of the drivers that they say they're tackling is to provide jobs, is to provide higher incomes, is to make housing more affordable. And those are the real issues, sir, that we should be debating. Those are the real issues that government ought to be focused on. But that's not what we're hearing, and it's certainly not what my community is hearing from this government.
Members, this debate